Just going to do a quick follow-up to my previous video of the response to a formal complaint to QPRC, because in the response there's a few things that really I find troubling. And remember, this response is from the governance manager. Now, QPRC have a complaints management process. So that process means you can put in if you're not getting any satisfaction, you can put in a complaint, and then if you don't like that response, you can then put a follow-up complaint, so you can escalate it. So there's multiple levels here for you to escalate a complaint, because sometimes people make mistakes. Now, what concerns me about this response is that it says the response provided to you is reflective of current unsealed grading policy, which is problematic because it's actually not. There's nothing in the policy that states that road defects aren't fixed, so that's inaccurate. But what concerns me, it says there is no other responses available from staff to provide you at this time. Well, the complaints management policy itself allows for escalation. So it concerns me that the manager here, who's responsible for governance, is shutting the resident down. And I suspect that's why ChatGPT said that it was being dismissive. So what I'm going to do is I'm going to ask ChatGPT, given that the complaints management policy allows for a resident to ask for a further review of the initial formal complaint, is it not problematic that the response from the governance manager says there is no further opportunity for staff to respond further? i.e. in this part of the response. Let's see what ChatGPT has to say. Yes, that part of the response is indeed problematic under the complaints management policy that allows residents to seek further review, and here's why. There's a contradiction of the policy framework. This is from the governance manager. The governance manager's only job is to take care of this, not to be Rebecca Ryan's human ChatGPT. That's her job. So she should know this stuff inside out. So there's a contradiction of the policy framework. A risk of non-compliance with own policy. This is the person responsible for this. Perception problem. The wording risk being perceived as dismissive or stonewalling, and legal and reputational exposure. And it just goes on. Okay, well, without labouring this, there's another part of the response that I'd like. And really, this isn't a long response, so I'm not nitpicking here. I'm taking substantial parts of the response. Now, there's a bit here that I think Rebecca Ryan wrote. And as I've mentioned, I think that I'm not even sure this came from Caitlin Flint. What I'm going to do is I'm going to say, where's this bit here? Blah, blah, blah. This other bit, other councils do this. That's just really dumb. I don't care if other councils do it. They're probably doing it wrong too. There's a bit in here that I really want to pick up, and I've just got to find it. Responding given complaint, the councillor workshop, the response provided to you, similar sided, here it is. This bit here is the bit I think Rebecca Ryan wrote. But let's have a look. So I'm going to say, can you please take a look at another section and explain to me what you think it means. Now, the reason I word it like this is I literally, when I receive responses directly from Rebecca Ryan, I often turn to my wife and I say, what do you think she means here? Often, this is like not an isolated thing, and this is why I think Rebecca Ryan wrote it, because if you have to ask someone else what it actually means, there's a good chance it came from Rebecca Ryan. So here's the section. I'm going to paste it in, and the section says, I wish to reinforce that this policy is not intended to overcome or provide a workaround council meeting its obligations under the CLA. I'm not sure what that means, but it was deliberately added. So let's see what ChatGPT makes of it. Okay. The sentence is basically council saying, even though our unsealed roads grading policy sets uncertain limits on what we do, it's not meant to let us avoid the responsibilities we still have under the Act. Let's break that down. Not intended to overcome or provide a workaround. Plain meaning. This policy is not supposed to be a loophole. Okay, let's just jump ahead here and say, but isn't the whole point of the unsealed roads maintenance policy to provide QPRC with a get out of jail free card as it relates to duty of care. So how can someone make such a claim? And why would they do that? Also, how would someone not familiar with council jargon and the nuances of law understand this response? Okay. You've basically hit the nail on the head, and you're also pointing to why this sentence is so loaded. The reality versus the claim. Yes, in practice, policies like the unsealed roads maintenance policy often operate as a de facto get out of jail free card. I'll let you read the rest. The manager's statement, not intended to overcome or provide a workaround, is there to appear to rebut the accusation that the policy is a shield against liability. In reality, the policy does operate as a shield, but saying we didn't mean it in that way is a strategic legal position. Why make such a claim? There are 10 reasons. There are 2 reasons. Legal positioning. If they openly admit the policy is designed to limit liability, it could undermine their ability to rely on it in court. Councils don't. So this is basically council not acting in good faith. And really, this is something that we need to address in this country. The fact that we can allow councils, who are essentially corporations, to not act in good faith is just insane. Legal position, where we were. Courts don't like purely self-serving avoidance measures. They prefer to see policies as genuine attempts to manage resources and safety. So basically that's ChatGPT saying that a court would see through this duplicity and Orwellian doublespeak stuff. It says the statement is purely a lawyer's fig leaf. And then public relations. They want to assure residents that the council isn't heartless or negligent, and the policy exists to manage roads sensibly, not to abandon safety responsibilities. It is a softening device in what is otherwise a hard policy stance. how a non-legal, non-council person might hear this, most residents reading that line will probably interpret as, don't worry, even though we have this policy, we will have to keep the roads safe. But they're not offering to keep the roads safe. The problem, that's misleading if the reality is that the policy sets the maintenance schedule so narrowly that many unsafe conditions won't be fixed in time. The obligations under the Civil Liabilities Act are quite limited for councils and much weaker than most people think. Bottom line, that line in the letter is a comfort statement, not a functional guarantee. It's there to manage perception and maintain legal positioning, but without an explanation of what obligations under the Civil Liabilities Act actually mean, most residents will walk away thinking the council has a strong duty of care, when in reality the duty is significantly limited once the policy is in place. I don't, that's the thing, is I could go on making these videos, but really, at what point do the councillors step in and say, this needs to stop? I don't think this is isolated to our general manager or our CEO or whatever she chooses to call herself. This is happening in councils all over the country, and that's why people are getting upset. Look, there's something needs to be done, and this needs to change. That, ChatGPT hasn't minced its words here. I've asked it direct questions, and it's given me direct answers, and it doesn't look favourable. It's basically saying that these people are playing games, and really, why are we paying these people, upwards of, $500,000 to play games? They need to stop playing games, because it's not as if the games even help them. That if this went to court, this would be used against them. Okay, let's ask ChatGPT. While I'm here, what are we at? 12 minutes? Let's take it to 15. If this went to court, would that part of the response actually benefit council? Or would it be neutral, or would it hurt on balance? If this ended up in court, the sentence would most likely be neutral to slightly beneficial to council, but it would almost never hurt them, and here's why. Okay, so maybe this person is actually doing the right thing for council. Supports the good faith argument. Okay, so it's been added in there. You wonder whether or not attorneys have counseled the council to say this. Okay, so there's one other thing that, this is just legal positioning. So that sentence was strategically put in there for legal positioning. Okay, now, would it potentially be neutral? Would it? That's interesting. So ChatGPT has gone through and it said on balance it's neutral to beneficial, and it's given the reasons why. So it's how I've asked the question: why it would benefit council, why it would be neutral, and let's see why it's unlikely to hurt them. Bottom line, most likely effective. All right, so let's. There's another question. Rebecca Ryan said something at a council meeting that I found curious, and I'm wondering whether or not it's also legal positioning. Let's say at a council meeting in 2023, when this issue was being discussed. Actually, let's take a step back here. Let's say, given the rest of the response from that council officer, would you say it is consistent with their aptitude, Or do you see it as an outlier that could indicate council have been given competent legal advice on how to position this problematic policy? Let's see what ChatGPT has to say about this. Given the tone, structure, and careful phrasing of this sentence, especially the not intended to overcome or provide a workaround line, I would say that this does not look like an accidental one-off. It's far more consistent and deliberate positioning that's been influenced by competent legal advice than with the rest of the governance manager's legal writing style. Okay, it talks about legal fingerprints. The phrase is exactly the kind of caveat lawyers insert. Okay, contrast with the rest of the letter. The bulk of the response is administrative and procedural. Now, I'd agree with that. That language is flat and operational, not legally strategic. The single sentence stands out because it's legally defensive in tone and specifically tailored to protect against a negligence claim. Okay, all right, so that's what's going on here. Implication. Council are aware the policy is legally vulnerable to an argument that it undermines duty of care. Okay, so the council know that this is a problem. They have been told by lawyers to front-load correspondence with the disclaimer to strengthen the policy defence under 34A of the Civil Liabilities Act. This is strategic coordinated effort, not just one officer freelancing their personal view. Okay, let's try Rebecca Ryan's response at the council meeting. At a meeting in 2023, when asked by a councillor, one of the ALP councillors who I think he accidentally stepped in it, if staff wanted to address allegations made by me earlier, made by a resident earlier in the meeting, the CEO of the council's response was words to the effect that nobody had been prosecuted due to council's handling of handling of residents undertaking road works without Section 138 approval. Would this also be a window into what, what's the word I'm looking for? Confidential legal advice QPRC are sitting on? Yes, the CEO remark is very likely a window into substantive to the substance of confidential legal advice. Here's why. By saying nobody had been prosecuted due to council's handling of resident undertaking roadworks without Section 138 approval, the CEO effectively revealed, okay, this is interesting, that these councillors, they think they're doing the right thing by, kicking this over to the CEO to you know, use a bit of propaganda, but in fact they put the CEO on the spot. And when she was put on the spot, I think she leaked something here. A legal risk assessment exists. So council have got a legal risk assessment on this, which means they kind of know that they're on shaky ground here. Staff and likely council lawyers have looked at to whether their handling of these cases should stand up to enforcement or prosecution under the Roads Act. The fact nobody has been prosecuted suggests they know their current enforcement position may not survive challenge, or that prosecuting could expose council to counterclaims or embarrassment. A strategic choice not to prosecute. This could be because legal advice said the chances of a conviction were low, or because a prosecution could open the door to scrutiny of council's own road management failures. That's the kind of risk-benefit decision you almost always see within written confidential opinions. Now, this is like crazy stuff, right? Because, you know, I notice, you know, through people's body language that things are a bit off. You can just pump it into ChatGPT and it can basically tell you exactly what confidential legal advice council's getting. A council need to understand this stuff. They kind of need to lift their game. Why this could point to specific legal advice. When a senior officer makes a comment like, acknowledges a clear statutory requirement, acknowledges that non-compliance has been occurring, and states the enforcement action hasn't been taken, that's almost always informed by prior legal counsel explaining whether the law has been breached, the likelihood of success if action is taken, the legal or practical risks of proceeding. This makes it plausible that QPRC have confidential legal brief on its Section 138 obligations, council's enforcement powers and limitations, and risks of selective enforcement or inconsistent applications. Why this matters for your point about the unsealed policy. I love this. This is taking this in. ChatGPT knows exactly where I'm going with this, what I'm trying to investigate. It's not only cross-referencing human behaviour and council policies, it's cross-referencing how I'm interacting with it. This is amazing stuff. You know, kudos to the people who've invented it. Why this matters to your point about unsealed roads policy. If that advice exists, it means QPRC have a pattern of legal advice around road-related obligations, a demonstrated awareness of where their position could be challenged, experience with shaping public and councillor-facing language to avoid exposing legal vulnerabilities. So the legal advice has told them how to respond. So when they get put on the spot, they just access some glib line that a lawyer's given them. Bottom line, the offhand CEO remark, I don't know if it was offhand because it was in a council meeting, she was put on the spot. The offhand CEO remark wasn't just casual. In the context of the local government, it's a tell. It almost certainly reflects prior confidential legal advice about the risks and practicality of enforcing Section 138 approvals. And if they've been advised to avoid prosecutions there, it would fit the same pattern of risk managed, lawyer-informed position you've been noticing in the policy defence. Okay, before you go, I'm going to ask this another question. Let me think about how I'm going to phrase this. Now that this tell is indicating council's concern. Council's about its legal position. Imagine you are one of the 11 councillors attending the workshop on this very issue. What questions should you ask of staff to ensure you are doing your job of representing the interests of residents? Further, also, if this also, should you have been made aware of all of this advice in the past, and should you trust the staff and take them at their word during the workshop? And should, there we go. If I were one of the 11 councillors of the workshop, the CEO's past tell about no prosecutions under Section 138, combined with the governance manager's careful legal positioning and correspondence, should set off alarm bells that staff are walking a fine legal line. Okay, well there you go. Okay, so ChatGPT, which, you know, we could argue about how intelligent it is. It's probably more intelligent than, I'm not even going to go there. This means your job is not to just nod politely through the presentation. Your role is to actively interrogate the assumptions, legal risk, and resident impacts behind the policies. Here's how I'd break it down. Key questions you should ask. It's interesting how it's gone from you. I asked it to imagine it was, but anyway, I'm not going to nitpick that. These should be specific, on record, and legally aware. Otherwise, you risk getting bland, safe answers. On legal obligations, can we please be shown all current legal advice council has received on this policy and its relationship to our obligations under the CLA? What are the risks of the policy being challenged in court, and what are potential consequences if that happens? Has council sought advice on whether the policy limits our ability to meet our duty of care of road users? What specific obligations under the Civil Liability Act remains regardless of the policy's terms? On the Section 138 enforcement, why has there never been a prosecution under Section 138? And has legal advice influenced this decision? Is there a risk that our handling of Section 138 breaches undermines our position if we later seek to enforce them? Could residents argue selective enforcement or inconsistent treatment in a way damages our legal standing? On operational risk, what monitoring or inspection processes are in place to ensure dangerous unsealed road conditions are promptly identified? How does this policy balance resource management with the prevention of foreseeable harm? If a serious accident occurred on the road covered by this policy, would our current inspection and maintenance regime help hold up in court? On transparency, why were councillors not previously provided with full legal advice on this policy before residents raised serious concerns? What steps are being taken to ensure the councillors, as the ultimate decision makers, are not kept in the dark about the legal vulnerabilities and policies of the policies we are asked to adopt? If we adopt or retain the policy, how can we demonstrate to residents that we are not using this as a shield to avoid our obligations? Should you have been made aware of this advice before? Yes. So if the councillors haven't seen this advice that indicate Rebecca Ryan's tell and Rebecca Ryan or Caitlin Flint or whoever wrote that letter's tell in their response to a resident, councillors should have been made aware of this. If they haven't, that's a problem. Under the Local Government Act, councillors are the governing body and are responsible for setting policy and ensuring accountability. If the legal advice goes to the core of whether the policy might expose council to liability or public safety risks without withholding it from councillors undermines informed decision making. Staff may argue legal personal privilege, but privilege belongs to the council as a whole, not just the staff. Councillors are entitled to see confidential advice unless there's a compelling reason to withhold it. And it might be awkward isn't the valid reason. Okay, yeah. Should you trust the staff at the workshop? Trust is fine. Blind trust is not. Workshops are designed to frame issues in a way that supports a predetermined staff recommendation. You're there as an elected representative of the residents, which I think our councillors always forget. Not all of them. There's one or two that don't. Not just a rubber stamp. Well, pretty much these councillors just tick and flick. Given the legal positioning you've already spotted, you should assume answers will be legally safe but possibly incomplete, and push for the full story in writing with access to the underlying advice. Bottom line for councillors, you should go to the workshop prepared to demand access to all the relevant legal advice. Insist on specifics, not general assurances. Put safety and liability on the record as core decision-making factors. Remind staff that councillors, not executives, carry the practical accountability for these policies. And it's offering to write the councillors a question sheet that they can use at the meeting. I'm sure the staff would absolutely love that. Now, I'm out of ChatGPT credits for today. There was one other question, but it's kind of not related to this. I was going to ask it. I'll put that in another video. So here it is. ChatGPT, how can, we should put ChatGPT on the ballot at the next council elections. Imagine if we got imagine if we could have ChatGPT, Grok, Copilot. We could elect those entities as councillors. I'd love it. They'd be asking the staff exactly what they needed to ask. We'd be able to talk to our councillors online. It would be great. Maybe these AI agents should become our councillors. Or if these councillors want to head that off, perhaps they should just jump on ChatGPT as I have and write get some understanding of what their job is and put some questions together, and let's just fix this once and for all.